Thank you. I now recognize Ms. Grosh for 5 minutes. You have to touch your microphone.
Excuse me.
Thank you.
Thank you, Mr. Chairman. I am the Assistant Legal Advisor for International Claims and Investment Disputes at the Department of State, where I've worked to defend the United States against Iran at the Hague Tribunal for nearly 30 years. Over that time, we have won some cases, we have lost some, and sometimes we have decided to settle. And I'm here today to explain as best as I can in this setting the settlement that was announced in January. As my colleague Mr. Backemeyer explained, this was only a partial settlement of a very large case. The rest of that case is ongoing at the Hague Tribunal today. Because of that, I am limited in what I can discuss in this public setting. As he explained, Iran and its lawyers are vigilant in scouring the public record for statements or information that they can use against us in these arbitrations. In fact, I can recall being in the Hague Tribunal many times and hearing Iran quote extensively from things that witnesses and members of Congress said in hearings, trying to use that to their advantage. These are multi-billion-dollar claims against the United States. So for some of your questions, I may need to defer the question to a closed setting, like the one that we did for House and Senate staff earlier this week. Now, to provide some background, the United States and Iran entered into the Algiers Accords in 1981, which created the Hague Tribunal. And it was primarily created to address claims of U.S. nationals, but also claims between the two governments. The agreement was entered into by the Carter administration, it was endorsed by the Reagan administration, and was debated by both houses of Congress. And in the end, it was determined that the Algiers Accords and the tribunal process were of great benefit to the United States and U.S. nationals. In the first 20 years of the tribunal process, it focused primarily on resolving claims of U.S. nationals for debt, contract, expropriation, and other measures affecting property rights. U.S. citizens and companies received over $2.5 billion in awards and settlements from that process. And there were significant government-to-government claims that were also filed at the tribunal. The majority, and certainly the largest, were by Iran against the United States, including Iran's large contract claims arising out of its former foreign military sales program. Like other FMS customers, Iran paid money into a trust fund that was used to facilitate prompt payment to the U.S. contractors working on Iranian contracts. But by January 1979, Iran had already been struggling to make the necessary payments on its more than 1,000 outstanding FMS contracts. In February 1979, Iran and the United States concluded a memorandum of understanding providing for the cancellation of many of the remaining purchases. The two sides worked on implementing the MOU and to wind down Iran's FMS program over the ensuing months. But as we all know, in November 1979, the hostages were taken and those efforts became to an end. The dispute over the FMS trust fund and interest, which resulted in the settlement in January of this year, was part of Iran's FMS claims that it filed with the tribunal in 1982. So you can imagine the scale of it and the money involved. It is a giant breach of contract case covering 1,126 huge FMS contracts. Before the settlement in January, other parts of the FMS claims were decided or settled some time ago. Indeed, settlement discussions over technical legal matters have been held in this channel for decades, typically led by the State Department legal advisor and the Iranian presidential legal advisor. My estimate is that since the early 1980s, through the Reagan, Bush, and Clinton administrations, some 40 rounds of claims meetings have occurred at this level. Indeed, the prior settlements with Iran of other portions of the FMS claims occurred during the first Bush administration. In 1989, for example, the United States and Iran settled a claim for $7.5 million for spare parts. It was paid from the judgment fund. In 1990, the parties enter into a partial settlement for $200 million from the trust fund, and this is the same trust fund that was the subject of the final settlement in January. And in 1991, the parties also settled Iran's claim for titled FMS assets for $278 million, and this was paid from the judgment fund. Apart from the FMS claims, there were other significant settlements between the parties, including in 1990, when Iran paid the United States $105 million in settlement of certain U.S. national claims and U.S. government claims. These settlements, and in particular the FMS settlements, were reached at key moments in the cases, such as before key hearings or when they were on the verge of going to decision. In the past 2 years, as proceedings at the tribunal have been advancing, we revisited the possibility of settlement of tribunal claims through 2014 and 2015. These discussions led to settlement of small claims that were the subject of ongoing hearings. They involved architectural drawings that were transferred to the Tehran Museum of Contemporary Art and for fossils that were transferred to the Ministry of the Environment. In the spring of 2015, after years of extensive briefing, Iran pressed the tribunal to schedule comprehensive hearings in these remaining FMS claims. The tribunal ordered both parties to file their respective proposals for the structure of hearings, and Iran filed its proposal on November 11, 2015. Iran was also pressing for a preliminary ruling on issues including the outstanding balance of the FMS trust fund and interest since 1979. They sought interest based on a provision in the 1979 Memorandum of Understanding calling for unexpended FMS funds associated with Iran's FMS program to be placed in an interest-bearing account. With the settlements over the smaller claims concluded in December 2015 and with the hearings in the FMS claims on the horizon, we were able to achieve this most recent settlement, which finally and fully resolves Iran's claim for funds in the FMS trust fund as well as interest since 1979. As we publicly announced in January, pursuant to the settlement, Iran received the balance of $400 million in the FMS trust fund, as well as roughly $1.3 billion representing a compromise on the interest. The trust fund balance of $400 million was paid from Iranian funds that were deposited in the FMS trust fund itself in connection with the program. The payment for the compromise on interest was provided out of the judgment fund, as was the case for the largest prior settlement of the FMS claims during the Bush administration. If Iran's claims for the trust fund balance and interest had gone to decision in the Hague Tribunal, the United States could well have faced significant exposure in the billions of dollars. Iran, of course, was seeking very high rates of interest for a period of over 3 decades. We were able to secure a favorable resolution on the interest and avoid the potential for a much larger award against us. The details of why we settled for this amount is litigation sensitive, and getting into that explanation would get at other issues still pending at the tribunal. Iran's lawyers would try to use my words, or maybe even your words, against us to help their position at the tribunal. But what I can say here today is that I believe that this settlement was the best thing for the United States. It was the best way to avoid a possible decision from the tribunal ordering us to pay a lot more. Thank you.
Thank you. The chair now recognizes Ms.